All right, you've made it to chapter 11 so far. So good for you. All right, we got to give yourself a applause there. You're doing good. You keep pushing forward. We're about halfway there. A little, well, maybe we're close to halfway there. Now we're going to focus on the documents that have to be provided to the trustee. This is an important part because by looking at these documents, you can also confirm what has been said in the bankruptcy intake since they don't always coincide. There could be contradictions there, and those contradictions could be potentially a problem. All right, so here we go. Stick around for the PowerPoint. All right, so here we are moving along, and now we're at the point where we're ready to, we already completed the intake, and now we got to start getting organized for the documents that the trustee needs. So this is also important because remember, when the client hired you or hired the office you work for, things could have changed throughout this time. And so while maybe you got bank statements initially dating back 6 months, if it's been another 3 months, we might be able to disregard the first of those 3 months and see if there any changes have occurred. And so when all this is getting ready, and I always get the documents always in advance before the case is filed for the simple reason that if you file it, you might have to end up chasing a client to get the documents, and then you don't get them there on time, or you have to rush to get them there, or the trustee says I didn't have enough time based on, usually they say 10 days before the hearing, so I'm gonna have to continue the hearing. Now time and money was spent and energy going down to a 341 meeting that is not going to take place. So I always try to get all those documents on my hands. Of course, part of the documents the trustee is going to want is going to be the tax returns. And with the tax returns, they can get a better idea if there's been any tax refunds or not. Tax refunds obviously will affect the case because that will determine if there's any assets that are not exempt. I always like to say that tax refunds are low hanging fruit. Trust, $5,000 in a tax refund is going to be better than $6,000 on exempting a car, because assuming that the client can buy back the car's equity and do a monthly payment plan, or even worse, if it goes to auction, these are more costs involved for the trustee. They have to, sell it at an auction, get it delivered there, pay everybody who's involved. So that's a lot of work and a lot of money. So tax refunds, it's just easier to go after that. So when you're looking at the tax refund, first find out if it's exempt or not. If it is, fine. We got no issues, we move on. But what if it's not exempt? What percentage is not exempt? Is it going to be $100? Trustee is not going to care. But if we're getting into the thousands, the client needs to know that. That's why I usually tell clients in the summer, I hope we're filing by October, November. I'd rather not. I'd rather do it before Thanksgiving, because we get into December. The 341 hearing is going to be 30 days later. So it's possible the trustee in January is already saying, how much you're getting in your tax refund, I'm going to claim an interest in it. So keep always that in mind when it comes to tax refunds. Let clients know. The last thing a client wants is to go to the 341 meeting and for the first time find out that they're going to lose their tax refund. The reality is everybody already spent the tax refund in their mind. And so when you take it away from them, it is literally like theft. You don't want to be in that position with client. So remember what I said in the prior video. I said delay, 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 right? That's sometimes the answer. Sometimes it's not. If you go back to the last video, I talked about issues with lawsuits. Sometimes you have to reach an agreement with a creditor just to buy time. This is another form now of trying to buy time. Let's do a little clock here, right? To make this look professional. There we go. No, it's a 9. Um, Sometimes you can't wait for whatever reason. This case has to be filed now. For example, suppose a foreclosure or a car repossession. We can't wait another 3 months to spend that tax refund. Well, if that's the case, then the answer, I know clients say, well, I don't want to lose my $4,000 tax refund. Well, the $4,000 is a lot less than losing your house. So it is what it is. Unfortunately, you didn't come see me in June where I could have, done something with the tax refund. So it has to happen. If there's time on your hands, then the answer is wait till the tax refund comes and goes. Comes and goes doesn't mean the client got the tax refund today. and then took it all out of their bank account tomorrow morning and then filed the next day. Basic question from the trustee: where's the money? What did it go on? So the tax refund could be spent. I never give clients a number. I just say, you know your expenses, just spend it slowly but surely, and then come back to me in a couple of months, and we'll take it from there. But tax refunds always an issue in bankruptcy cases. Now, some not all trustees want the last 6 months. Some do, but make sure when you're reviewing those pay stubs and before you even file, that you've made sure to count overtime, bonuses, and commissions. Now, here's the problem. Might be September when the client is seeing you. You have to ask, do you get bonuses? Even if you don't ask for whatever reason, maybe the client dropped off all the documents at the office and didn't sit around to talk to you. They were in a rush or you were in a rush. Then the answer is, as always, let me go to this one instead. This is where I wanted to go. Then the answer is you have to look at the tax returns and make sure that there was no bonuses there and the pay stubs to see a discrepancy in income. The clients made the same amount. Then you have to look at the pay stubs and see if the last paycheck in December there was some sort of maybe there's a bonus that some places give a bonus depending on business. Some do it every year, so it really depends. But you have to ask that from the client to make sure that there's not going to be any issues. All right. The side hustles, I already spoke about that before. I talked about how that will affect the means testing. So keep that in mind. One other thing to keep in mind with the pay stubs is make sure the amounts that are being deducted for whether it's an IRA or 401k. The reason is it depends on and this would be Schedule I. That's where that expense would go. It really depends on the district. Miami seemed to be very flexible with that, but I know, speaking with lawyers in other districts in other states, that some trustees see any deduction on a pay stub for a retirement account, and they just lose their mind. So you have to know your district. Just because I got away with something in Miami doesn't mean I'll get away with it in the Northern District, in Tallahassee, or let's say Jacksonville, or any other state, and vice versa. So you have to know your area, and you have to know whether these deductions are going to be too high for the trustee, or is it just enough that the trustee is not going to care. But always make sure to get the pay stubs, because without that, you really can't do the calculations when it comes to the bankruptcy petition. Now, part of the reason you're going to get the balance on the car and look at the last car statement, which is what the trustee is usually going to ask for, it's just the equity issue. They want to make sure that there's no equity there, and if there is, they're obviously going to pursue it. Generally, lawyers are going to do online valuation like kellysbluebook.com. That's good enough. But I can tell you when the numbers are a little too high and it could be potentially a problem. Remember, this is just a website that's asking generic questions. Is it good condition, fair condition? This is kind of subjective, right? So when that happens, I just tell client, you know what, just go to a dealership. The dealership is going to deduct every scratch and dent on this car, and that should bring the value of the car down. And the trustee is going to, say, okay, that's fine. This is better. Typically, the only reason we don't do that from the beginning is you're making clients do all this work to pretend they're going to go sell their car somewhere when they're really not. Now, I do want to point out that when it comes to car leases, note that this is an executory contract. It's not going to go where you're going to put all your other secured debts. Basically, it's separate. Remember, a lease is, you have the option to buy at the end, and basically it's a rental. So it's not an asset that's going to get listed in the schedules. It has no value. It has a value if the lease expires today and the client decides to go forward with the purchase, then sure, it's got a value and we can move on. So just be careful where you put leases, because it's not the same as owning a car. Now, when you're looking at all the documents regarding the client's homestead property, make sure everything matches. Okay. And again, this goes back to the simple issues of maybe the client is renting out. Maybe the client has a driver's license. Let's say the client just moved in with their significant other, and they said, let me go ahead and update my license. But all of a sudden, they're getting mail there, but everything else doesn't seem to match. And if the trustee catches that, they're going to say very easily, this is non-homestead property, and we're going to go forward and potentially lose the home. So everything has to match. These are little things that sneak by clients, but it cannot sneak by you. The driver's license better match. The tax returns, if they move, that's fine. But make sure it all matches. Make sure the tax returns, they aren't claiming they're married when they're not. I've seen that a lot where clients like, yeah, but we've been together 20 years, but you're not married. The IRS says you're not married. Until the IRS code changes that a domestic partner after X amount of time is your wife, then fine. But you cannot be filing tax returns saying you're married, because obviously the tax refund comes in higher, and that is going to be considered tax fraud. And there's some trustees that will pursue that matter. So you have to be careful with that issue of even what the tax returns are stating on there. And of course, remember that once again, if this doesn't match, then we could have non-homestead issues. Okay. Now, the HOA, homeowners association, a lot of time clients ignore them. They say, well, I got to pay my mortgage. I don't want to lose my house. The HOA can move forward on a foreclosure on you. And so, that has to get paid as everything else. And if they're behind on their payments, then we have to, worry about doing a Chapter 13 instead, to make sure that they can catch up. Okay. Now, when I'm talking about transactions, that's important too, because the reality is sometimes you have clients that are over here and they're just trying to increase their expenses. Sometimes they're thinking, let's just have some fun, and they're going out spending way too much money. I've had clients who literally go out of town every single weekend, or they're eating out multiple times a week, or ordering out. And all that means I have to delay the case. Every lawyer needs clean bank statements. If they're not clean, then the answer is we're going to delay. If we have an urgency again, then the answer is we'll roll the dice, but the trustee might object or push you into a Chapter 13. Now, the reason I mentioned strange transactions is sometimes there's the deposits in there that you say, why is this deposit in there all of a sudden? And that happens more often than you can imagine, where the trustee, or you, if you caught it early, say, why was there a $5,000 deposit? Sometimes not most times, it's just completely innocent. Someone needed to, cash a refund, tax refund, or whatever it could be. Maybe their bank account was frozen, so they transferred it to your client's account. That's fine, but you have to know about it. Again, you don't want to go to court and see that this happens. I've seen clients do literally a Ponzi scheme, where they give $100 to someone, and then all the people in line before them give them $100. So I've seen clients make $500 a month off that. Is it illegal? Yes, but it's there. And I said, "What's the side hustle?" And they told me that. I go, "Yeah, it's going to be a problem because there's no W-2." So guess what? I need clean bank statements. Okay. Now, retirement accounts, this is another area where there's a lot of confusion. A lot of times, clients know that accounts are basically exempt. You can't touch my retirement, right? Well, yeah, I can't, but I can. You have let's say your 401k or IRA is over here, and this is your checking account. You transfer that money over here. Guess what? This is non-exempt funds. So a lot of times clients do withdraw X amount. They say, well, let me pay the bankruptcy lawyer, get rid of them all at once, and let me, just have a padding in there. Well, what's the amount? Because I've seen clients in there with $10,000, and I'm like, that's just not protected. And even worse, if a creditor comes in and freezes that account, it's not protected, and they're going to lose that money, whether through the creditor or through the trustee. So we have to make sure that's not going on, where they've transferred funds into the account, which is going to affect. I literally just told clients, just transfer it back. Don't worry about it. That's allowed. It's not a big deal. So keep that in mind. That could be a quick and easy solution. I also want to point out that with retirement accounts, a lot of times people do borrow money against their account. Remember, people, when they're in debt, they try to get out of debt mostly by getting into more debt. And if they touch their 401k, which is common, you're going to see that deduction on their pay stubs. So that's why you have to review pay stubs. But just note, for purposes of the bankruptcy petition, we'll go over that later, it is secured debt. It is tied in to the retirement account. So guess what? I'm just going to put ND here. That's non-dischargeable. They're not going to wipe that out in bankruptcy. They're going to have to continue paying it. The expense is going to be listed. It'll be listed on Schedule I. I'm sorry, Schedule I, because that's coming straight out of their pay stub. So you'll see that. You'll put that there. But when it comes to wiping it out, it's a secured debt, and so at the end of the day, it's not going to get wiped out in bankruptcy. Now, with lawsuits, we already spoke about this before, and I had mentioned before in the prior, do we have to hurry up or do we have to slow down with these lawsuits? Every case is different. Just understand that too many times clients tend to ignore this stuff, and the consequences, as you can see here, bank accounts are frozen, liens on their cars or their home, or they garnish their wages. But SOFA, back to that again, Statement of Financial Affairs, does ask if there's any lawsuits pending. You have to put the case number, you have to put the district, and you have to put what type of case it is. Why? Because again, are we dealing with a creditor that's suing? Okay, that's really not going to affect the bankruptcy case, right? But what if the lawsuit is trying to collect on a personal injury case? Then now you can see where the trustee's ears perks up, and they're going to want information on that. So typically, they might just want the first few pages of the complaint. A credit card lawsuit could have, easily 20 pages. They start including cardholder agreements and everything else. But if there is a lawsuit, that is going to go into SOFA, and chances are the trustee wants a copy of it. If it's something that we're talking about non-exempt assets, they're definitely going to want a copy of that. Finally, for this Chapter 11, domestic support orders. Remember, with domestic support orders, that is not dischargeable in bankruptcy. So we're talking about spousal support and we're talking about child support. But I also am going to mention divorce tied into a DSO, because bankruptcy affects a divorce and a divorce affects a bankruptcy. And how? Right here is the answer. If there's a substantial amount, and substantial, I mean enough money to perk up the ears of the trustee, saying, well, I'm going through a divorce. Okay, first question, is there a home? Yes. What's going to happen with the home? Well, nobody can afford it, neither me or my spouse. So we're just going to sell it and keep the money. Okay, is there enough money to go buy another home? No, not really. It's not going to be enough for a deposit. Lenders want 30% or whatever. We only got 15,000. This is a $15,000 problem. So that's why a lot of times I might have a client come see me and I find out about the divorce, and then I tell them, you know what, talk to your spouse. Maybe you should both file together. I know things are rough right now, but file together and deal with the divorce later, because you both are going to lose this. And a lot of times it's not just one client filing divorce, their spouse is going to file too. And so the issue with that is you're both filing bankruptcy and you both are going to lose this money. So you most likely protected. 9 out of 10 times, a lot of states just double the exemptions on homestead when it's a husband and wife filing. So guess what? That resolves that problem, right? But a lot of times, if there's all this equity being from the home, if it gets rolled over into another home, great, it's not an issue. But if it's not, then all of a sudden the client thinks, oh, I'll just file for bankruptcy, I'll wipe out all my debt, and then I have the money from the sale of the home, and I'm all good. I'm comfortable again financially. And the answer is no, 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 no. The trustee is going to take those sale of funds because they're just sitting in your bank account. That's not protected. So definitely look into that's why one of the questions on the intake is there a case number? And again, goes back to SOFA. What's the case number? Divorce, foreclosure, car repossession, credit card, child support. What is it? And so your ears should perk up as well when you find out that there is a case pending and there's assets involved in a divorce, because those assets might be protected married and they may not be protected during the divorce. Now, DSOs are listed. Pay stubs again will determine if it's being deducted automatically from their pay stubs. You'll see that. If so, it goes. That's the income deduction order that you see here. That will go listed on Schedule I. If they're paying child support directly to the other parent, then it goes on Schedule J. What you got to make sure is avoid that this expense is doubled up. So just make sure that it's either one or the other, and it's not. And finally, when it comes to this issue, what if they were divorced? Then same thing. Make sure you look at the marital settlement agreement. Make sure that there's not this money that's being left over. A lot of times, The answer is the other spouse is keeping the house, but in 6 months, they have the opportunity to refinance and buy out the other spouse, which is now the debtor or your client in this case. And so the trustee asks, how much is that buyout again? And the answer is, oh, it's $60,000. Oh, I hope the client plans to buy another home with that, because right now is not the time to file for bankruptcy, because the trustee could say, I want the $60,000 in that. These are issues that I guarantee you 9 out of 10 lawyers ignore in bankruptcy, and probably 10 out of 10 lawyers ignore in family law. So it's very important to find out if there is a divorce case. Find out, is this a simple divorce? No kids, no property? Oh, no, we have a house and we're going to sell it. Then put on the brakes and start digging in, asking questions to find out. Maybe at the end of the day, there is no equity in the home. Great. Maybe they're doing a short sale, right? They're underwater and they have negative equity, but maybe they don't. And if the answer is they don't, then that's where we have the problem, and we have to figure out what is the next step, which is typically going to be delay the bankruptcy as much as possible. Okay, so we are done with chapter 11. We keep moving forward here. We're going to get ready now for the next chapter. So thank you for joining me as well with this today's presentation. As always, reach out to me, post any questions or comments you have in the section below, and I'll be more than happy to respond. All right. Take well, study hard, you paralegals and legal study students. I hope you're doing great in class. Take care, everybody.